Check, 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 check. 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 Check, 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 check.
I might go ahead and start. Just because we're going to have opening statements. Just because we're going to have opening statements. And your members will get in here. We should get started. Committee will come to order without objection. Declare recess at any time pursuant to House Rule 11, Clause 2. The chair may postpone the question today. Postpone the question today on the matter or adopting an amendment for which. Welcome back to the committee. Welcome back to the committee. Committee will come to order without objection. Ask the gentleman if he believes in the Pledge of Allegiance. The Pledge of Allegiance. Clause 2. The chair may House Rule 11, Clause 2. Today. Postpone the question today. Matter or adopting an amendment for which. Welcome back to the committee. Welcome back to the committee. Committee will come to order without objection. Ask the gentleman if he believes in the Pledge of Allegiance. Pursuant to notice, we call up HR 6570 to protect members Act markup and move the committee markup and move the House report favorable to the House.
HR 6570.
Objection, the bill will be considered as read. The bill will be considered as read. The chair now recognizes the gentleman. HR legislation. Mr. Biggs for legislation. Mr. Mark.
Thank you, Mr. Chairman, and I thank Mr. Chairman. I thank the members hearing this, and I thank the men that served on the task force committee that served on the task force that was appointed Mr. Fruta of California as we were able to work with our counterparts who agree with much of what we have. Congress enacted the Foreign Intelligence Surveillance Act of 1978. Federal government revelation. It seriously used warrantless surveillance that resulted in random privacy. Despite efforts to rein this in, the federal government has continued to use its powers improperly and often to agree with much. In February 2020, Director Ray testified before the people that they should not lose any sleep over the vast majority of FISA applications. Former Director Comey labeled FISA a top-tier FBI Despite these claims, in 2019, Inspector General Michael Horowitz exposed how the FBI had violated its authorities under FISA by improperly spying on Trump campaign associations. The reports revealed that the FBI failed to recognize the significant risks posed by systemic noncompliance with the Woods procedure. Again, in May 2023, Special Counsel John Durham released a report on FBI's Crossfire Hurricane investigation, which not only supported Inspector General Horowitz's findings, but also found that political and confirmation bias led the FBI to lie to the Fisk in order to improperly spy on the Trump campaign for an entire year. In April of this year, we held a hearing with Department of Justice Inspector General Michael Horowitz and members of the Privacy and Civil Liberties Oversight Board to discuss the FISA program and to determine whether reforms to Section 702 are needed. It became increasingly clear that significant reforms are necessary, and in July we held another hearing to further discuss these needed reforms. At the end of this year, the end of this month, Section 702 of FISA will expire. Reports in recent years have exposed the government's and specifically the FBI's abuse of this program. A law designed to provide tools to collect foreign intelligence and prevent terrorist attacks has been warped into a domestic spy tool used to target Americans. In 2021, the FBI queried the communications of more than 3.3 million U.S. persons, wrongfully. In 2022, the FBI was still conducting hundreds of U.S. persons queries per day. A recent FISA court opinion revealed the FBI conducted more than 278,000 improper searches of U.S. persons' communications in 2022. These backdoor warrantless searches included Americans who were in Washington, D.C. on January 6, 2021. These backdoor warrantless searches included Americans who participated in Black Lives Matter protests during the summer of 2020, and they included Americans who were in Washington, D.C. on January 6, 2021, even though they had nothing to do with the riots near and in the Capitol. They included searches for our colleagues on the Intelligence Committee, Congressman Darren LaHood, an unnamed U.S. Senator and a state senator. They included warrantless searches of 19,000 donors to a congressional campaign, ostensibly to see if any of them were influenced by foreign entities. These actions violated the privacy and civil liberties of Americans and likely infringed on their Fourth Amendment rights. FISA Section 702 explicitly states that it may only be used to target non-U.S. persons located abroad for the purpose of obtaining foreign intelligence information. But it's clear that the government is using communications acquired through this program to conduct backdoor searches of Americans' communications. And most of this is done without even having obtained a warrant. Section 702 information acquired without a warrant can later be used by the FBI in criminal prosecutions unrelated to foreign intelligence or national security. The FBI has misused privileged spying powers to conduct rogue surveillance on innocent Americans. We cannot allow that to continue. I have called for serious reforms of FISA for many years. The FBI and federal intelligence agencies use scare tactics to convince Congress that these unchecked powers are the only method available to protect our nation from harm. Well, every American should be scared to know federal agents are spying on them, even if they have nothing to hide. We need to prohibit warrantless surveillance of Americans and hold accountable any federal official who violates the civil liberties of Americans. To prevent further abuses of Section 702 by the FBI and broader intelligence community, the Protect Liberty and End Warrantless Surveillance Act requires all intelligence agencies and the FBI to obtain a warrant from the Foreign Intelligence Surveillance Court before conducting any query of a U.S. person. It would also drastically reduce the number of FBI officials authorized to conduct such queries. The bill will also bring much-needed reforms to the FISC, increase transparency, and ensure that those who violate the civil liberties of Americans will be held accountable for their actions. The bill closes the data broker loophole to ensure the government cannot make an end run around the Fourth Amendment to purchase the data of Americans, which was unanimously supported by this committee earlier this year. However, this bill will not restrict the intelligence community from acting quickly in the face of impending danger due to its reasonable exceptions based on the exigent circumstance of each situation. Additionally, if surveilling an innocent U.S. person's data is so vital to national security, the intelligence community may get the consent of that U.S. person that they intend to surveil without needing to get a warrant. With these exceptions, this bill ensures that the government must have a good reason if it wants to target Americans' data. It is clear that reforms to FISA are desperately needed, and the Protect Liberty and End Warrantless Surveillance Act will implement significant reform. I yield back.
The gentleman yields back. Before recognizing the ranking member, let me again thank the chairman of the crime subcommittee and the sponsor of the legislation, as well as Mr. McClintock and Ms. Lee, who worked on this, who focused on this issue for several months, and our entire side of the dais, as well as our staff. And I also want to thank ranking member Nadler, where we worked for a number of weeks and months on this legislation and have had great conversations with him and our staff and your staff, as well as Ms. Jayapal and others on the committee. This is nice to have the committee work this way from time to time, particularly on something of this level of importance, and so we appreciate that. And with that, I would yield to the ranking member for an opening statement.
I thank the chairman. Thank you, Mr. Chairman, for holding this important markup today. The Protect Liberty and End Warrantless Surveillance Act, or the Protect Liberty Act, is the product of a year-long effort in which I was proud to join Chairman Jordan and Mr. Biggs in leading. Over the past year, the committee held 2 hearings on FISA that helped frame the important issues that called out for reform. We brought in government watchdogs from the Privacy and Civil Liberties Oversight Board and the DOJ Inspector General, who described the FBI's ongoing compliance issues with Section 702. We heard from witnesses from the civil liberties community about the impact of these violations, and we consulted with a range of experts on what changes were needed to help prevent inappropriate queries of the FISA 702 database. And we engaged with the Department of Justice, the FBI, and the other agencies that use this authority, an exchange that leaves, I suspect, virtually every member of this committee convinced that Section 702 is essential to national security and ought to be reauthorized in some form. This legislation is the product of that exhaustive process. On Monday, Mr. Biggs and I unveiled the Protect Liberty Act, bipartisan legislation that would reauthorize and reform Section 702 and would require robust civil liberties protections throughout the Foreign Intelligence Surveillance Act. I anticipate that we will hear that word a lot today, bipartisan. It is not a word often used to describe our committee. But the process that led to this bill was one of true bipartisanship, one where members on both sides of the aisle sat down together to find common ground. FISA reform will only be successful when we work together, and I thank the chairman for allowing that bipartisan process to play out. Let me take a moment to put my support for this important legislation into context. Like many of my colleagues, I have never supported the bill to reauthorize Section 702 on the House floor. I have in the past worked with my Republican colleagues on this committee to reach a compromise that would place appropriate restraints on the government's use of this powerful authority. Unfortunately, those thoughtful approaches were never presented to the full House for a vote. Indeed, one wonders if we would even be having this debate today if the House had passed the bipartisan effort that I advanced with former Chairman Bob Goodlatte back in 2017. Today in this hearing room, we have an opportunity to put this conversation back on track. For too long, FISA has enabled the surveillance of Americans without adequate safeguards to protect our civil liberties. No one disagrees that our intelligence agencies play an essential role in keeping us safe, but it is unfair to expect that the individuals who carry the grave responsibility of rooting out terrorist threats should also be required to make judgments about how to protect the constitutional rights of those surveilled. They need Congress to enact guardrails. And in Congress, that role falls to the House Judiciary Committee. Time and again, the FISA court has found that the government overstepped in its use of FISA authorities. Nowhere is this lack of compliance more apparent than in the case of FBI querying of U.S. person information contained in the 702 database. Although Section 702 authorizes only the targeting of non-U.S. persons who are outside the United States, we know that massive amounts of U.S. person data are swept up under this programmatic surveillance. We also know from what reporting is available that the government has a lot of this data, and that much of it could not have been obtained without a warrant had they tried to collect it directly. And even though there are some constraints in when the FBI can query U.S. person identifiers, those protections do not necessarily work. For example, restrictions on FBI queries did not prevent searches of over 100 Black Lives Matter protesters. They did not prevent a batch query of over 19,000 donors to an unnamed congressional candidate. And they did not stop over 278,000 other non-compliant FBI queries of the 702 database that occurred just last year. 278,000. The single most important reform we can put in place to combat these abuses is a warrant requirement for U.S. person queries. This legislation will do just that. The legislation before us today would impose a probable cause warrant requirement on searches using U.S. person identifiers with certain reasonable exceptions, such as cybersecurity cases and in exigent circumstances. It would also significantly limit the number of FBI personnel who can conduct U.S. person queries, increase the types of cases where an amicus must be appointed at the FISA court, and impose much-needed additional transparency to the entire system. Although I expect this bill to pass today with overwhelming bipartisan consensus, I know our approach will have its critics. Some will say we have gone too far towards reform. Some will say we have not done nearly enough. And some will attempt to convince us that a mostly symbolic warrant requirement, one that exists on the books but applies to no more than a handful of cases a year, constitutes meaningful reform. With respect, they are wrong. I believe we have struck the right balance here, and perhaps the only balance that can pass the House of Representatives at this time. A warrant requirement like the one imposed in the Protect Liberty Act is the reform we need to protect Americans and to allow surveillance laws to continue to keep us safe while also protecting our essential liberties. To end where I began, I have never voted to reauthorize Section 702. I am deeply uncomfortable, as we all should be, with the notion that it is permissible for the government to search our most private communications without a warrant simply because they were aiming for non-U.S. persons overseas. I understand, however, that Section 702 authority has become increasingly important to our national security. I recognize that letting it expire altogether would not be wise. The Protect Liberty Act was written with that reality in mind. Although I have long advocated for a range of reforms to the surveillance powers we vest in the intelligence community, federal law enforcement, and our state and local partners, this bill is not a catch-all for every reform we might like to see enacted one day. It is instead a balanced first step designed to preserve the underlying authority while curbing the abuses that most threaten our privacy. I thank Mr. Biggs, my colleagues on both sides of the aisle, and the bipartisan group of civil liberties and national security experts we consulted for their hard work getting us to this point. I urge all members to support this legislation And with that, I yield back the balance of my time.
Well said. The gentleman yields back. Without objection, all of their opening statements will be included in the record. The chair now recognizes the gentleman from Arizona for the purposes of offering an amendment in the nature of a substitute.
Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 6.
Without objection, the amendment in the nature of substitute will be considered as read and shall be considered as base text for the purposes of amendment. The chair now recognizes the gentleman from Arizona to explain the amendment.
Thank you, Mr. Chairman. I'll be quick. Also, I wanted to thank Mr. Nadler for his opening statement, for working with us on this important issue, and Ms. Jayapal, Ms. Lofgren, and the others across the aisle, and the staff from both sides of the aisle in this who've worked so hard to deliver this bill and this amendment. The most important aspect of this amendment in the nature of a substitute is the section dealing with the Fourth Amendment is not for sale act, something that passed out of here almost unanimously. I think it was unanimously with one vote voting present. And with that, Mr. Chairman, other than that, it does nothing to alter the substance of the bill, and I'll yield back.
Gentleman yields back. Who seeks recognition? The chair recognizes the gentlelady from Florida, Ms. Lee.
Thank you, Mr. Chairman. We are here today to bring overdue reform to Section 702 of the Foreign Intelligence Surveillance Act. We all acknowledge the need to enact comprehensive reforms designed to protect American civil liberties. However, we also face a critical need to reauthorize Section 702 of FISA. In a bipartisan effort, members of the House Judiciary Committee have met with representatives from the House Intelligence Committee, industry experts, coalition groups, and the intelligence community to attempt to find common ground in ensuring the preservation of our constituents' constitutional rights while also defending our homeland from acts of terror. In particular, I'd like to thank Chairman Jordan, Mr. Biggs, Mr. McClintock, and our Democrat colleagues on the committee who have worked so hard in this endeavor. In an environment of pervasive threats of terrorism on our homeland, tools like Section 702 are a critical part of preventing conspiracies against the United States. However, in its current form, American civil liberties are at risk of being violated. We are gravely concerned about past instances of abuse and the potential for future abuses of the 702 querying program and of the FISC court. We are committed to ensuring that intelligence tools are used for the American people, not against the American people. And the work we have done this Congress will ensure that we protect civil liberties while we also protect our homeland. The Protect Liberty Act will strengthen civil liberty protections and ensure that FISA remains an effective instrument for terrorist surveillance by implementing strong reforms to use, oversight, and penalties for abuse. Thank you, Mr. Chairman. I yield back.
Gentlelady yields back. Who seeks recognition? Gentleman from Wisconsin is recognized.
Mr. Chair, I support H.R. 6750, and I urge its passage. The revelations by the Department of Justice inspectors of court have shown a disappointing and frankly alarming pattern of abuse by the FBI in its use of U.S. person data. These abuses have led to an increased calls for changes to Section 702 from both sides of the aisle. For example, the President's own Intelligence Advisory Board stated in its July 2023 report that complacency, a lack of proper procedure, and the sheer volume of Section 702 activity led to the FBI's inappropriate use of Section 702 authorities. Similarly, the Bipartisan Privacy and Civil Liberties Oversight Board was unanimous in stating, although all U.S. person queries by the intelligence community present privacy and civil liberties risks, FBI queries, procedures, and practices pose the most significant threats to American privacy. But both groups have also been unanimous in the value of Section 702 to U.S. domestic and national security. I think our bipartisan bill strikes the right balance between our need to protect national security with our need to protect civil liberties and our Fourth Amendment rights as Americans. First, H.R. 6750 will curb the FBI's abuses of Section 702 by restricting the use of U.S. person data. This bill will limit the number of FBI employees able to perform U.S. person queries, requiring that queries will only be for the purposes of retrieving foreign intelligence information, and subject U.S. person queries to the same evidentiary standard as other domestic search under the Fourth Amendment. It also provides more transparency into FISA court or FISC to ensure what happened with FISA application of Carter Page will never happen again. Finally, it provides for more accountability measures to ensure those who continue to abuse the query procedures face steep penalties for their actions. I want to thank my colleagues from Arizona, Mr. Biggs, for leading on this important issue, as well as Chairman Jordan and Ranking Member Nadler for their good faith negotiations to get this bill to a place where I believe it will pass overwhelmingly out of this committee. And I urge the committee to support the bill. I yield back.
Gentleman yields back. The chair now recognizes the gentlelady from Washington who's been working tirelessly on this legislation.
Thank you so much, Mr. Chairman. I have an amendment at the desk.
Clerk will report.
Amendment to the amendment in the nature of a substitute to H.R. 6570 offered by Ms. Jayapal of Washington.
Without objection, the amendment will be considered as read. The gentlelady is recognized on her amendment.
Thank you, Mr. Chairman. I want to start by thanking you, thanking Ranking Member Nadler and Representative Biggs for offering this very strong legislation to overhaul FISA and to protect Americans' Fourth Amendment right to privacy. I'm very proud to be an original co-sponsor of this bill, the Protect Liberty and End Warrantless Surveillance Act. This bill is a huge step forward to protecting Americans' privacy and civil liberties by simply requiring the government to get a warrant before searching for Americans' communications, fixing the loophole that currently allows the government to purchase Americans' sensitive data without a warrant, and more. I also want to just take a moment to thank my colleague on the other side of the aisle, who I've also worked very closely with on these issues, Representative Warren Davidson, who is not on the committee, but whose leadership has been critical, and Representative Zoe Lofgren, who's unable to be here, but whose long-term leadership has been essential. I want to offer a friendly amendment to strengthen the bill by addressing reverse targeting, a practice where intelligence agencies select foreign targets with the purpose of securing communications of persons in the United States. We know that despite Congress's direction to intelligence agencies to minimize the retention and use of Americans' information incidentally collected under Section 702, the agencies have actually done just the opposite. Last year alone, they conducted 200,000 warrantless backdoor searches for Americans' private communications. They've also regularly abused the weak protections that are in place, including baseless backdoor searches for people exercising their First Amendment right to protest, journalists, and even members of Congress. This bill takes an important step in requiring a warrant to search Americans' communications records, which would substantially reduce the risk of surveillance abuses, but warrants alone cannot eliminate the risk entirely, particularly for willful abuses. Similarly, a warrant requirement cannot prevent Section 702 databases from being hacked or otherwise accessed improperly. Accordingly, it's important not just to protect Americans' privacy at the point that agents are performing searches, but also at the time of collection. My amendment would accomplish that by strengthening existing prohibitions on the reverse targeting of Americans. That is, collection supposedly targeting a foreign person located abroad, but actually intending to collect the information of an American in contact with a foreign person. Currently, Section 702 prohibits the government from targeting foreign person if the purpose of the surveillance is to spy on an American. In practice, that means that even if the purpose of the surveillance is almost entirely to gather intelligence about an American, the government can still evade the Fourth Amendment's warrant requirement as long as it has even a minor interest in the foreign person as well. Some may argue that the intent of the law is clear, but the standard is far too weak to protect Americans' constitutional rights. There should be no shortcuts to warrantlessly surveil Americans. Under my amendment, the government could not target a foreign person if a significant purpose of the surveillance is to spy on an American in contact with that foreign person. When the government wants to surveil Americans, it should be required to get a warrant or a FISA Title I order. It should not be able to evade this requirement because it also has some interest in a foreign person in contact with an American. If that were the case, the government would, in theory, be able to capture warrantlessly all of an American's international communications. And the Constitution simply doesn't allow this. I hope my colleagues will join me in supporting this amendment to strengthen this excellent bill. We must ensure robust protections for Americans throughout the process, not just at the query stage. And aside from this particular issue, I hope we can continue working together to ensure that all surveillance happens pursuant to congressional authorities. I'm also eager for us to further crack down on data brokers and go further to protect Americans' medical and mental health records, financial records, and other private sensitive information. In the meantime, I am really delighted at the outcome of the bill to date. It's a crucial step to protect Americans from warrantless surveillance, and I hope to see it swiftly move to the House and Senate floors and urge President Biden to sign it into law without delay. I yield back.
Lady yields back. Does the gentleman insist on his point of order?
I withdraw my point of order.
Point of order withdrawn. The gentleman from Florida is recognized.
Thank you, Mr. Chairman. I thank the gentlelady for the amendment and would hope that she would engage in a brief colloquy with me to discuss how the nature of this amendment to stop the reverse targeting that troubles us, that we've seen in the Inspector General's report, interfaces with this executive order, this 12333 executive order. And so is the gentlelady confident that if the amendment were adopted, that there wouldn't be a mechanism for reverse targeting under that executive order? I yield.
It doesn't touch 12333. I am confident that that this is an amendment that will help us to ensure that there's no evading of what we are all seeking, which is warrants and authority to surveil Americans.
I'm going to support the amendment. I think that it's virtuous in that goal. But does the gentlelady worry that if we leave the 12333 in place, that there might be some effort to undermine the good work of the amendment and the underlying bill?
As the gentleman knows, I have been worried about that. I continue to be worried about that. I think we're going to have to do everything we can to make sure that we're paying very close attention to this and continuing to try to move forward and have authority over that particular issue.
Yeah, I'm concerned about it because, you know, in my discussions with Ms. Lofgren, who, as the gentlelady states, is a recognized expert on this issue, I initially thought, well, let's just let this expire. It's been such an abused authority. Let's let it expire and see if we can design something anew that isn't littered with all of the loopholes that have allowed these abuses of people's civil liberties. And what Ms. Lofgren expressed to me is that if we were to just allow the legislation to expire, that these executive orders would persist with the veneer of authority, and there wouldn't be the warrant requirements that we're all fighting for here. And so I am worried that all of this great effort that we've put into warrant requirements and our civil liberties is a bit illusory if what the Intel Committee is really arguing for is the preservation of this executive order that then allows the reverse targeting and the end run around the Fourth Amendment. And so that, I mean, that's a concern of mine that's going to persist throughout this. It's certainly not a reason to oppose this good amendment, but I think we do need to acknowledge that there's a lot of work to be done. And it's a tell to me that the folks at the Intelligence Committee are willing to give us so much on the statutory reauthorization, but then at the same time, they're willing to give us nothing to bring 12333 into the scope of our reforms. And it's because they want a regime to exist outside the scope of those reforms. So I would yield to the chairman if the chairman has any perspective on how these things we're doing now will interface with that executive order and how the Judiciary Committee ought to think about those things.
I would just say, that, like the sponsor of the amendment, I have concerns. I think most members do. But I do think the product we are putting together, that we have started with, and the amendments that we anticipate being offered from both sides of the aisle, not all, but most, are going to even improve that product. And then I think we have to think in a political dynamic. We know that the Intel Committee is marking up something different tomorrow, and that there will be a vote for the full House next week. So we think this, in consultation with the ranking member and members from both sides and the working group and everything else, we think this is the best product and the best way that we can do the most to protect the Fourth Amendment and other concerns for Americans' liberty.
No, I agree, Mr. Chairman. I think you've endeavored upon yeoman's work here, but I don't want to be back at this committee a year from now, 18 months from now, where we've enacted our reforms and we've got some inspector general sitting before us telling us that the executive order provided all these avenues for the exact same abuses and the exact same conduct. Because I think what troubles us all in a bipartisan way is when you see the activities of the FBI and others exceed the scope of the law.
Would
and
the
if
gentleman yield?
Certainly, I'd yield to the ranking member.
I'd simply point out that to the extent an executive order 12333 or any other goes against the legislation that we passes, it must yield to the legislation.
Right. No, I agree with that, which is why I wanted to take the time to really get from Ms. Jayapal an understanding of how those things weave together. And it sounds like the amendment sponsor is saying this wouldn't provide a direct conflict with 12333.
Would the gentleman yield?
Certainly.
This particular amendment does not touch 12333. That does not mean, as I said, that I don't share your concerns about 12333. I think there will be other amendments that will touch different pieces. I don't think that there's a perfect solution in this. I think that what we are doing today is recognizing this will be an enormous step forward, and given everything that you've mentioned about the dynamics of the intelligence community and our belief that we need to have strong tools, of course, to protect intelligence, but they cannot fundamentally undermine the civil liberties and privacy of Americans. And I think that is the place that we are in. We're literally, I think, making steps that, I don't know about you, but maybe 5 years ago I didn't really believe were necessarily possible, but here we are. And I think we just need to be extremely vigilant, recognize that, you know, in our initial offerings, I think you and I probably agreed on 12333 and where we should go with that. But I think this is a big step forward. The amendment on its own, I think, is an important piece just to continue to close some of those ways in which we think that people might try to evade what our intent is to protect the privacy and civil liberties of Americans.
Thank you very much. I yield back.
Gentleman yields back. The ranking member is recognized.
Thank you, Mr. Chairman. I rise in support of the amendment. I commend Ms. Jayapal for it. And I think a very simple explanation of it is very simple. By prohibiting targeting when a significant purpose of the collection is to target a U.S. person, not just when the purpose is to target a U.S. person, the amendment would prevent intelligence agencies from skirting constitutional protections when they seek to gather intelligence about Americans. They could no longer say, well, you know, the entire purpose was not the U.S. citizen. This would say if it's a significant purpose, it's not permissible. I support the amendment to limit the ability of the intelligence community to improperly collect information about U.S. persons. I commend Ms. Jayapal for her dedication and hard work on this issue. I think the amendment strengthens the bill and improves it, and I urge its adoption. I yield back.
Gentleman yields back. I agree with the ranking member. Anyone else seek